right. Hi, everyone. Welcome to our gala webinar on the global legal challenges of cannabis advertising. Thank you so much for joining. So my name is Evie Boris, and I'm with Miller Thompson in Toronto, Canada, and I'm the moderator for today's webinar. Although I won't be doing much moderating, I will be letting our gala members speak about cannabis advertising in their respective jurisdictions. So as you know, cannabis has been a hot and trending topic, especially in Canada, and I'm sure it's true for various jurisdictions across the world. So our hope for today is that we answer your questions in terms of promoting cannabis, what you can do or say if you're a brand or advertiser. So I'll introduce our speakers for today. Our gala members are Todd Halpern, who will be talking for the USA, a perspective from the US, myself, Evie Boris, for Canada, Ricardo Enriquez for Portugal and EU generally, Karima Sheikh for South Africa, and Bruno Bertolotti for Uruguay. And without further ado, I'll pass it along to Todd to talk about the United States.
Abby, thanks so much, and thanks to Gala for sponsoring the presentation and the webinar today. So understanding that time is short, I'm going to dive right in, and I purposely began with some discussion, and let me just let you all look at this disclaimer here, with the discussion of terminology. And I think a lot of these words get thrown around and create a lot of confusion because there's a lot of imprecision in the language. And to really understand how a particular product containing cannabis is regulated, it's very important to understand the terminology involved, particularly with respect to marijuana and hemp. And so marijuana is going to trigger a completely separate regulatory regime that doesn't cover products that only include hemp. And what's important to understand is that both hemp and marijuana are forms of cannabis. And what distinguishes the two is really just the amount of THC that each contains. THC, as you probably know, is the cannabinoid, the chemical that's in the plant which creates the recreational high that people get from using marijuana. And so if it has less than 0.3% or less of THC, it constitutes hemp. And the reason that's extremely important, and there you see the formal name for THC, by the way, delta-9 Tetrahydrocannabinol. The reason why that's important is because if you are hemp, you are not subject to regulation by the Drug Enforcement Administration. You're subject to a lot of other regulation that we will go through in a minute, but that is critical because if you're marijuana, as you'll see in a moment, under federal law, you're essentially illegal in the United States, and we'll go a little further as my presentation goes on. A couple other terms to familiarize yourself with. So I referred to cannabinoids earlier, cannabinoids being certain chemicals that are contained within all cannabis plants. Latest count that I've heard is about 112. There are certainly more than 100, and I think there's a bit of debate right now as to whether or not there are others that exist, each potentially with their own medicinal or pharmacological utility and subject to a lot of research right now, which is just speeding up the amount of interest that's in this area. Terpenes is another term you'll often hear. Terpenes are other compounds that are contained in cannabis plants. They're in all cannabis plants, but they're contained in different forms and different numbers. And those numbers are important for some of the properties of the cannabis plant. Most importantly, or most prevalently, is how it smells and how it tastes. And there are many who believe there is something called an entourage effect with certain extracts from cannabis, and this means generally what they're referring to is the mix of terpenes that are contained in the particular extract, which may produce unique or different medicinal and other therapeutic benefits, depending on how they're arranged within a particular breed of cannabis. So there are a lot of varieties and a lot of things that the research is looking at. I'll skip over THC, but only point out that there is an approved THC. It's actually a synthetic THC product approved as a medicine or drug here in the United States. It's called Marihuana. And again, THC is what creates the recreational high users of marijuana can get. Now, CBD is entirely distinct from THC. It is another cannabinoid. I know this is something that has been of great interest, particularly in the United States over the past couple of years. Importantly, and you'll understand why in a minute, there is an FDA-approved drug that is CBD. It's called Epidiolex, and it's for the treatment of a specific seizure disorder, I should say a couple of seizure disorders, called Dravet syndrome and Lennox-Gastaut syndrome. All right, so what I am going to try and quickly cover is a legal and regulatory overview of CBD and then of marijuana. And when I say CBD here, what I'm really talking about are products containing hemp-derived CBD as opposed to cannabis that would meet the definition of marijuana. I'm not going to review a lot of these slides in detail, but I give this to you for, so that you have something when you download this to look at and study as you'd like. Here, the only point I'll make here is that there are several federal regulators who have a say or have some rules that govern over these products. And note on the bottom that states also have their own rules. And so understanding how a product is regulated, a CBD hemp-derived product is regulated, for that it's important to understand both federal and state rules, which can make it incredibly complicated. So one of the agencies I'd like to focus on is the Food and Drug Administration, the FDA. And when you're talking about FDA regulation generally with the CBD product or any botanical product, the question that's of usual foremost interest for the advertiser is whether or not they're going to be required to get pre-approval, pre-market approval from FDA before they can go to market. And the answer usually depends on whether or not the product can be sold as a dietary supplement or food, which would enable going to market without getting pre-market approval from FDA. Generally, if the product is considered a drug, it would require pre-market approval. Now, without getting into a long, involved analysis, I'll just tell you that for the most part, with a botanical ingredient like CBD, the product is only going to be a drug if you are marketing it as something that can treat, cure, or prevent a disease. Now, that's a very oversimplified explanation, but I think it's enough for now. And what's interesting about CBD from the standpoint of FDA regulation is that there are challenges and potential problems with marketing it as a dietary supplement or food. And the reason is for two provisions that I provide you in the next two slides, 18 and 19. And what these provisions say in summary is that an ingredient that has already been investigated as a drug cannot be sold as a dietary supplement or food unless it was sold as a supplement or food before it was investigated as a drug. And because Epidiolex exists and was studied going back several years ago, the FDA takes the position that all CBD products are illegal. I should say all CBD products cannot be sold as dietary supplements or food, to be more precise. Now, in addition to FDA regulation, it's important for me to touch upon other regulators of advertising, the Federal Trade Commission being the most important. And the Federal Trade Commission is essentially looking at whether or not any claim is truthful or not misleading, and they have been somewhat active in looking at advertising claims for CBD products. In fact, they have worked jointly with FDA to give several warning letters to companies. These are some of the state agencies that generally get involved, depending on the states, who have a variety of rules. There's also state enforcement by the attorneys general, who are generally responsible for regulating advertising in the states. I need to wind down now, and I know I'm going very quickly here, but I do want to touch on marijuana. And the key point here is that marijuana is illegal in the United States under federal law. However, there has been a very interesting issue arising because of several states, in fact, a majority of states, now have legalized it, and I'm using air quotes there, either as a medicinal product or for what is generally referred to as adult use. And there is a very interesting dynamic going on, because even where it is legal, so to speak, in the state, it is still technically illegal under federal law. And it's just because the federal government has decided, as a matter of policy, for reasons that I provide in the slides, not to enforce against companies that are operating lawfully within a particular state. It creates a lot of complications with payment and banking in particular, and other kind of aspects of CBD and marijuana businesses. So I think that's all my time. I know I've rushed through this. I've tried to provide a lot of detail so you can take home and ruminate over some of the things that I mentioned. And thank you again, Gayla. And I think I turn it now back to Evie.
Yes. Thank you, Todd. All right, so we will dive right in for Canada. I just want to make sure that the slide goes. All right, so here's a little bit of the agenda of what that will frame my time. So I will talk about the legislative framework for cannabis, what is cannabis, so what's included, what's excluded, and then we'll dive into what's prohibited and permitted content when it comes to promotions and advertising of cannabis. So the legal framework in Canada, there are two legislative regimes, the federal and the provincial regime. So just to give you a little bit of background, medical marijuana has been legal in Canada for quite some time, but what's new and trending right now is recreational cannabis, which became legal in October 2018 in the form of dried, fresh, and oil form. And then recently, in October 2019, we saw the introduction of edibles, topicals, extracts, and concentrates. So it is the Cannabis Act that sets out the groundwork for medical cannabis and recreational cannabis as well, and it is a highly restrictive act. So the intent is to curb access to use to cannabis, and also curb access to cannabis from the black market. So it is highly restrictive, and the federal government kind of keeps a check on everything that involves cannabis, from supply to sale to process and anything in between. The federal government is involved. So if you are dealing with an activity that touches on cannabis, you will most likely need a license from Health Canada, and by any means, those licenses are not easy to get. Also, just want to flag that this is a fairly new regime for recreational cannabis, as I was mentioning. So there will be a lot of unanswered questions, and we will definitely be going through some growing pains. But the Cannabis Act is, by all means, the cannabis Bible when it comes to recreational cannabis and medical cannabis, advertising, marketing as well, and also import-export licensing and the definition of cannabis. Health Canada is the regulator that will enforce this act. And then we also look at the provinces. So the provinces each have the authority to set out the rules and procedures that relate to distribution and sale of cannabis in the province and what the age of majority will be. So the federal act sets out the minimum standards, and the provinces have the option of actually going stricter. So, for instance, in Quebec, the age of majority is 18, but they bumped it up to 21 when it comes to cannabis. And also, Quebec does have broader advertising restrictions when it comes to cannabis as well. So it's important when we're talking about cannabis in Canada to, yes, look to the Federal Cannabis Act, which is the Bible, but also to keep in mind that there are provinces that do have some statutes that govern promotion and sale as well. All right, so we'll start with what is cannabis. So in general, it's a plant that belongs to the genus cannabis and any of the following, so a part of the cannabis plant with some exceptions that I'll briefly talk about in the next slide. So hemp, stalks, and non-viable seeds are not considered cannabis under the Cannabis Act. The phytocannabinoids, so as Todd was mentioning, the most popular ones are THC and CBD. They are considered cannabis. A substance that includes any of the phytocannabinoids or any part of the plant is considered cannabis under the Cannabis Act. So in Canada, you'll hit different levels of regulations depending on the plant, the level of concentration of some of these phytocannabinoids. You'll hit different frameworks and legal requirements. But for the purposes of this webinar, we'll concentrate on cannabis with THC and CBD. Obviously, it can take different forms, as I mentioned briefly in the beginning. It could be dried, fresh, and plant. And recently, in 2019, we have edibles, topicals, and extracts. A little bit of background on that. The edibles came into force in October 2019, but it's very limited on what you can say. So you can't have any nutrient claims, energy claims, diet claims. You can't associate with alcohol or tobacco. And there's also some restrictions on packaging labeling and the ingredients that you can put in the product. So, for instance, you can't be adding caffeine unless it's naturally occurring in edibles. So if you're in the edible, topicals, or extracts market, be sure to look out for the packaging and labeling and content restrictions as well under the Cannabis Act. CBD, as Todd mentioned, it's pretty black and white in Canada. CBD is cannabidiol. It's a phytocannabinoid from the cannabis plant, and it also could come from industrial hemp. So regardless of its source in Canada, if your product contains CBD, it is cannabis under the Cannabis Act. We understand it doesn't have the same psychoactive effects as THC, but it does have an effect on the brain, and it's still a controlled substance under the United Nations Drug Convention. So this is what warrants it being regulated as cannabis in Canada. So let's move on to now industrial hemp. I'll just touch briefly on this, what it is in Canada. So it's a plant with a concentration of THC of 0.3% weight for weight or less in the flowering heads and leaves. So it's not cannabis, but it's still a regulated product under the industrial hemp regulations. You'll need a license to produce or import it, and you can't make any psychoactive claims about it. And depending on the claim that you want to make, for instance, if you want to make a cosmetic claim or a therapeutic claim, Canada does have different regimes for that as well. So if you're thinking about making a therapeutic claim, you'll have to keep in mind that there's still licenses required under the Natural Health Product Regulations or even the Food and Drugs Act. So cannabis promotion, so what exactly does that mean? The Act does define promote as, in respect of a thing or service, means to make for the purpose of selling the thing or service or direct or indirect representation that is likely to influence and shape attitudes, beliefs, and behaviors about the thing or service. So in a nutshell, if your content is trying to generate a sale, you are most likely going to fall within the promotion regulations under the Cannabis Act. Wanting to flag that this does not apply to packaging and labeling, those are subject to different rules under the Act. Of course, there's some exceptions. So if we're dealing with an educational topic, a scientific work, a musical work, a report, a commentary, or opinion in which a brand or cannabis brand or advertiser has not provided any compensation or payment, then we are not considered promotion. Also, if we're a business-to-business, so if a licensee is promoting its cannabis product to another licensee under the Act, that is also not considered a promotion under the Cannabis Act. So let's look to what you can do. So the framework here is basically promoting cannabis is prohibited unless you fall under one of the exceptions. And even if you do fall under one of these exceptions, you cannot under any circumstance do the following. So communicate about cannabis information about price or distribution unless it's factual. The advertising cannot appeal to young persons. You can't use testimonials or endorsements. You can't depict a person, a real or fictional character, or an animal. You can't use lifestyle advertising. There are no sponsorships generally. And of course, you can't make any false or misleading representations. So as an example, this lovely chihuahua with the marijuana wreath around its neck will never see the light of day in Canada, neither will this cartoon character smoking marijuana. I also mentioned lifestyle advertising, so you won't really see the term lifestyle advertising in the Act, but it's defined. We kind of give it this term based on the following. So the Act says you cannot present a brand, element, or cannabis in a manner that associates it with a positive or negative emotion about a way of life that includes glamour, recreation, excitement, vitality, risk, or daring. So it's kind of subjective. And I just wanted to pull up this slide, which has an image, because it came up in one of the conferences that I attended recently, where one of the major cannabis players had this image using the two Muskoka chairs facing a lake, and the regulator kind of objected to it, saying that it was lifestyle advertising. So it's important to note that before you use any image, you kind of have to consider what the general impression is and what emotion is it invoking, what's the general takeaway. So what exactly is permitted? So regardless, with the restrictions that I set out in previous slides about not using endorsements or sponsorships, these are one of the three exceptions that we can use. So we have informational promotion, brand preference promotion, and brand element promotion. So information promotion is presenting facts to the consumer about cannabis, either cannabis or its characteristics, a cannabis accessory or service, the availability or price of cannabis. So that's pretty much what you could talk about if we're in the informational promotion bracket. Under brand preference promotion, we can promote cannabis, an accessory or service related to cannabis by means of its brand characteristics. Important to note that brand characteristics is not defined under the Act, so a lot of advertisers are left questioning what exactly they can say about what brand characteristic means in terms of advertising. And then there's also brand element promotion. So it's pretty much placing a brand name, trademark, design, or slogan on a thing that evokes cannabis, an accessory, or a cannabis service. All right, so if we're in the informational brand preference bracket, there are some restrictions on who can actually use informational or brand preference promotion. So if we're talking about promoting cannabis, the people who can do it are the ones that are authorized to produce, sell, or distribute. I also want to flag, if we are talking about cannabis accessories or services, you don't need to be authorized, but you're still subject to the same conditions that I'm going to talk about right now. So in order to use informational or brand preference advertising, the communication can either be sent to an individual that's 18 years or older. So again, that's province dependent. Like I mentioned, in Quebec, the age would be 21. The communication must be identified to the individual by name. Also, the advertising cannot be in a place where young persons are not permitted. So you could be in a bar. Also, the regulations add this other caveat that even though we're promoting in a place where young people are not allowed, we need to make sure that when we're promoting it, for example, in a bar, that our promotion can't be audible or seen from outside that place. And if we're dealing with a digital or a social media ad, it should be age-gated. The Act doesn't say age-gated per se, but it says that the person needs to take reasonable steps to verify that young people can't access this content. Reasonable steps, again, isn't defined, but with talks with the regulator, we know that, for instance, asking someone to check a box that they're of the age of majority would not be enough, would not be a warranted verification process. Instead, what we look to is actually ask the person to input their age or their date of birth to verify that they're of the age of majority. Quickly, brand element promotion. So you can put your brand element on certain things, but that thing cannot be cannabis. It can't be, again, appealing to young persons or associating to young persons, and it can't evoke a way of life, glamour, or recreation. You could only put one brand element on a time on a thing, and also there are size restrictions. For instance, if you want to use the name of your brand, the type height has to be smaller or equal to 4 centimeters in height. Again, like I mentioned briefly, Quebec is a very restricted province when it comes to cannabis advertising. Pretty much you can only promote cannabis in a printed newspaper or magazine that is sent and addressed to an individual that is years 21 or older and identified by name, or within a cannabis retail store licensed by the Quebec government. And even if you are allowed, it can only be factual information. Brand element promotions are not allowed in Quebec. Again, there are some exclusions. So if you're thinking about going into the province of Quebec, please contact your legal counsel to help you navigate the legal framework of that province. Also, just wanted to lastly close with this example. I know I've talked about a lot of restrictions when it comes to cannabis advertising, but we've been seeing some major cannabis players take on a completely creative approach where they associate their brand with something that's completely outside of cannabis. For instance, here there's an image of a plant tunnel that was in downtown Toronto, and it's Afria, brought to you by Afria, which is a major cannabis player, and it's just plants. And they're saying, plant positivity. positivity. Walk through this tunnel, feel happy that you're surrounded with plants, and it has nothing to do with cannabis. So a lot of brands are taking a creative approach and just elevating their brand without actually talking about cannabis, and we're seeing that happen a lot with various brands. So I think with that ends my presentation. I hope you took something away, and I will pass it on to Ricardo.
Okay. Thank you very much, Edie. Following Tade's presentation, I will now talk to you about the legal framework in Portugal. So the first thing I wanted to explain to you is that in some ways Portugal stands out from other European countries when it comes to the regulation of illicit substances, including cannabis. We have some old laws dating back to 2001 that dealt with a general regime for trafficking and consumption of narcotic drugs and psychotropic substances. And basically this law, while nothing was technically made legal, consumption, acquisition, and possession of drugs for personal consumption was decriminalized. Portugal is not the only European country to have this sort of drug policy. Other countries like Spain, Italy, and Slovenia also have similar laws. We, however, have some new laws, and these new laws were passed for the legalization of medical cannabis in Portugal, with an update being passed in January 2019 that requires all cannabis products, including hemp products, to be regulated and authorized. This means that not only the production of cannabis for medicinal purposes, but also the industrial hemp farming must now submit to a licensing procedure. And whilst for medicinal cannabis, there is only one competent entity, the National Medicines Authority. In the case of hemp, there are now two competent entities to take into consideration. So Infarmed and the Food and Veterinary General Directorate. So this another point that I would like to make is the difference between the different types of products that we consider when advertising cannabis products. And we have to differentiate the regulations that have affected the various parts of the industry. As you can see in this slide, the only products not requiring a prior authorization from Infarmed, but that nonetheless, as I explained, may require notification to the Food and Veterinary General Directorate, are those which fit the indicated criteria. If there is a history of safe and significant consumption before 1997, if they either derive exclusively from hemp seeds, namely seed oil, hemp protein, or hemp flour, or alternatively, if they contain THC levels under 0.2%. Different laws may come into play when determining the compliance with the law and in advertising cannabis, hemp, or CBD. We have to take into consideration the general rules of the Portuguese Advertising Code and of the Law on Unfair Commercial Practices, as well as the specific rules on the use of medicinal products, and also the legal regime for medicinal products for human use. All of these diplomas contain some rules that may sometimes overlap, but that are all important to assess on a case-by-case basis and to determine the applicable legal regime. In the case of authorized cannabis products to be used for medicinal purposes, the rule is of a general prohibition, being the only exception the possibility to advertise in technical publications or in specific information intended exclusively for doctors or other healthcare professionals. The law contains specific requirements for these technical publications or information materials, dealing essentially with the labeling and determining that it must be in Portuguese and contain the information that is indicated here. The name of the product, the type of preparation or substance, and statement on the composition and content, and other information, including, this is important, the registration number of the authorization with the health authority Infarmed. With regards to advertising of all other cannabis-derived products that comply with the third criteria of only deriving exclusively from hemp seeds and or containing the THC levels under 0.2%, those are subject to the general rules applicable to advertising. So it's important to notice that advertising of these kind of products can contain no reference to therapeutic properties on their labeling or in any related advertising. So when advertising for foodstuffs, nutraceutical products, or herbal products, it's important to take into account the legislation that we have seen here, which contains the listed key principles of which I would highlight truthfulness and the use of Portuguese language. I would like now to tell you a little bit more about the general reactions in the Portuguese market to this legal framework and what have been the latest developments, and share some examples of what types of advertising have caught the eye of the regulators and the enforcement activities. 5 companies have already obtained authorization on the import and export of cannabis plant for medicinal purposes, and there are now 2 requests for authorization to place cannabis-based preparations on the market that are under evaluation. In fact, the Hemp-NOT has created an office for cannabis for medicinal purposes, and also a website with specific frequently asked questions. As this has been a matter that has raised a lot of doubts and concerns, including the number is as high as 304 requests just last year. So these are some examples of infringing advertising that I'd like to show to you, and this one refers to 2 products that are being promoted as containing CBD, which in fact may mislead potential consumers if they cannot contain the CBD, and so consumers acquiring them would be in the hope of obtaining the corresponding benefits, but in fact the products could not address that. The packaging and labeling are complemented in this case with posts on social networks such as Facebook, where they advertise the benefits of CBD, which is not the case as I mentioned. Also, another case here of a more blatant infringement of Portuguese rules is this one, where the advertiser promises miracle cures to everything from stress and anxiety to Parkinson, Alzheimer, anorexia, migraines, heart conditions, epilepsy, and rheumatism, which is clearly a clear infringement of Portuguese law. One last example of products found in a well-known local store in Lisbon are these chocolates clearly marked with an indication of CBD when they only contain hemp. The announcement of these products in the context of legalization of cannabis for medicinal purposes are misleading and creates false expectations in, above all, patients who seek therapeutic properties associated with cannabinoids and this plant. The last slide, just to show you a recent inspection from the Supervisory Authority of Economic and Food Safety, which has targeted an enforcement activity on 50 market operators and actually seized several products containing CBD and or non-authorized THC content. Those products were vaporizers, flavorings, liquids, and electronic cigarettes and creams worth around 15,000 euros that were seized due to different reasons, but mainly related to insufficient or incorrect labeling, both in non-food items and food items. And that's all for Portugal. I'll now pass on the slides to South Africa and Karima.
Thank you very much. My name is Karima. I'm from South Africa. Hello to everyone listening in. So in South Africa, let me just move onwards. The sale of cannabis has not yet been fully legalized, but there have been some promising developments as of late. In September 2018, the South African Constitutional Court declared unconstitutional certain provisions contained in the Medicines and Related Substances Act that criminalize the use or possession of cannabis. The provisions in question were found to infringe upon the right to privacy entrenched in Section 14 of the Constitution. In a nutshell, the Constitutional Court's decision means that it is now legal for adult persons to possess and use cannabis in private and to cultivate cannabis in a private place for personal consumption, of course, in private. The citation to the decision is on the slide, as is a picture of a very happy Mr. Prince, who was a party to the proceeding. So while the decision by the Constitutional Court does not change the law on trading in cannabis and cannabis products locally, many considered it South Africa's first step towards joining the rank of countries in which cannabis trade and use has been legalized. And there are certainly a number of stakeholders locally advocating for this. In its decision, the Constitutional Court did afford our local parliament 24 months to rectify the constitutional defects in the Medicines Act. Over a year has passed now, however, and there haven't been many developments on that front. But in May last year, the Minister of Health issued a government notice descheduling certain preparations containing CBD. The government notice is only effective for a year. So to simplify things, there are two categories of cannabis which can be legally sold in South Africa. There's those covered by the Minister of Health notice, and those are products containing a maximum daily dose of 20 milligrams of CBD, and also processed products made from cannabis raw plant material that contain no more than 0.001% of THC and 0.0075% of CBD. So those products can be freely sold in South Africa, and there are no licensing requirements. The second category are those which fall within the various schedules of the Medicines and Related Substances Act. These are subject to the Act's requirements, and one can only sell these products in South Africa with a license from the South African Health Products Regulatory Authority, known as SAPRA. I've included a link to a very useful FAQ document prepared by SAPRA. This document is very helpful in providing a very high-level summary of the position relating to cannabis, the sale thereof in South Africa. So if a product falls within the second category, namely if it is qualified or identified as a medicine, then naturally the various advertising laws applicable to medicines will apply. The main statutory provisions are found in the Medicines and Related Substances Act. The Act deals inter alia with the requirements for packaging inserts and wording that is permissible and required wording, etc., on packaging inserts. Insofar as self-regulation is concerned, the advertising of medicine is governed by the South African Code of Marketing Practices for Health Products, also known as the Marketing Code. I've included a link to the Marketing Code there also. The definition of advertising in the Marketing Code is quite broad, and it includes any statement, pictorial representation or design that is intended either directly or indirectly to promote the sale, use, or supply of a health product. The requirements for promotional and advertising material are set out in Chapter 5 of the Code, and the Code distinguishes between self-medication and prescribed medicines. Some of the requirements relating to self-medication include those that are very familiar to us. For instance, the promotional material or advertising shall not be misleading about the nature of the health product. Exaggerating or all-encompassing or embracing claims cannot be made. No unfair advantage can be taken of the reputation of a brand or a trademark or a proprietary name. Advertising shall not be aimed principally or exclusively at children under the age of 12. Advertising shall not contain improper, alarming, or misleading claims about recovery. And also, an advertisement for self-medication shall not refer, either expressly or by implication, to products used or assisting in the treatment of serious forms of diseases, conditions, ailments, defects, unless SAPRA has provided prior approval for that. So in addition to the Marketing Code, there's also the Advertising Regulatory Board, which is a self-regulatory board that governs commercial advertising in South Africa. The Advertising Regulatory Board, the ARB, has a code of advertising practices, and guideline 1 to that code it deals with medicines. And again, the same sort of guidelines and rules found in the Marketing Code and the Medicines Act are reiterated in this code. But in addition, for instance, Article 4 of that code states that a product cannot claim to relieve stress unless it is registered as a medicine and the claim has been approved by SAPRA. And then the code also, prescribes that words such as fast and effective may not be used in their superlative form unless approved by SAPRA. So, insofar as descheduled CBD products or so-called descheduled CBD products are concerned, the general provisions of the ARB's advertising code will apply, and I've included a link to those provisions there. The code prohibits, for instance, advertising that is offensive, that offends against good taste or decency, or is offensive to public or sectorial values and sensitivities. In terms of the code, adverts must also be honest, and they should not abuse the trust of the consumer or exploit his lack of experience or knowledge. Advertisements should also not contain anything which might lead or lend support to criminal or illegal activity, nor should they appear to condone such activities. In addition, any claims made in an advert must be substantiated. The ad should also not contain any statement or visual representation which either directly or by implication or omission or inaccuracy or by exaggeration is likely to mislead the consumer. In addition to the code, if a CBD product, for instance, is intended for consumption by pets, and there are many CBD products aimed at pets in the market in South Africa at the moment, Appendix I to the ARB code will apply, and that relates to specific advertising requirements for pet products. Some of those, obviously, it includes a provision prohibiting the advertising of pet food that is misleading, and also one of the regulations requires that the term natural can only be used to describe pet food components to which nothing has been added. So those requirements must also then be met with if your CBD product is intended for application or for consumption by pets. And insofar as edible CBD products are concerned, the ARB code also has an Appendix J, which deals with food and beverage advertising, and then the local legislation is the Foodstuffs, Cosmetics and Disinfectants Act, and there are labeling and advertising regulations in terms of that act, but specifically for foodstuffs, which will also apply, and I've included a link to those regulations. The regulations again include the same requirements regarding misleading advertising, for instance, and they also prescribe what content is required and allowed on product packaging. And then finally, we also have the Consumer Protection Act in South Africa. This act will apply to the extent that it deals with general advertising or marketing to a consumer. The act contains the same provisions that most of the other documents I've referred to contain, but also specifically prohibits bait advertising. So in conclusion, for now, the commercialization of cannabis, apart from the products referred to above, and then hemp, which is separately regulated locally, it's largely theoretical since the cultivation and use of cannabis is only allowed in private. But legitimate commercial opportunities will inevitably shape policy, and we hope to have a more tailored framework for advertising in the market very soon. And that's it for me. Thank you.
Well, hi everyone. In first place, and in the name of Ferrer, thanks to Gala for this invitation. As you probably know, Uruguay was the first country to legalize almost all cannabis-related activities, and to also specifically regulating medicinal cannabis and hemp. Our national laws almost cover all the range of options for activities, for example, access to recreational use, home cultivation, research and development, cultivation, processing, manufacturing, market, import, export, everything you can imagine, except, for example, the sale of recreational cannabis in coffee shops, for example, as in Amsterdam. Let's go for the next slide. So, in any case, to engage any of those activities, some authorizations or license may have to be obtained. Those authorizations or licenses will depend, of course, on the activities, but principle if they are related to psychoactive cannabis or non-psychoactive cannabis. That is referred also in our laws as hemp or as CBD products. It's kind of the difference of that in the USA between CBD products and marijuana. So how is the cannabis market right now in Uruguay? Well, there are a lot of authorizations and licenses granted for activities. For example, there are 40 licenses already to cultivate hemp, 8 licenses for industrialization activities, 70 R&D licenses, and 3 for projects of cultivation of psychoactive cannabis for medicinal purposes. Last 2 years in Uruguay were quite significant regarding investments. That's why we had a lot of authorizations granted. Many companies from the U.S. and Canada came to Uruguay and invest. Among others, for example, Oakley, Aurora, Quiron, and Pharma. However, despite of the market progress, there are still too many regulatory restrictions for successful business in Uruguay. That is the reason why today, for example, only one CBD drug and one CBD cosmetic have been authorized by the Ministry of Health to be marketed here. And this is kind of the same situation of advertising. Advertising, as we will see, we will explain, it's practically banned in all its terms. However, there are some exceptions that we will see. These are the regulators, the Institute of Control and Regulation of Cannabis, the Ministry of Health, and the Ministry of Agriculture. This depending on the activities and if it is of psychoactive cannabis or non-psychoactive cannabis, they are the ones that grant the authorizations and regulate on advertising. In this slide, you may see an opinion of an important businessman that reflects a little bit the situation of the business in Uruguay. We have a law that it's a Formula One car, but then they tell you that we can only go third year. Okay, that's how our industry is feeling right now. We have advanced a lot in authorization, in investments, but for example, on advertising, there are a lot of restrictions. The products can get to be known, and that makes really difficult the business. So, in this slide, you can see that our laws are very restrictive in relation to cannabis advertising. Our principal cannabis law establishes that all kinds of advertising for any psychoactive cannabis products is forbidden. Moreover, the law forbids conducting tournaments, contests, and public events that promote cannabis use. This broad provision is also included in the law regulatory decree that refers to medicinal cannabis. So all psychoactive cannabis products, even if they are for medicinal purposes, it's banned. So, what about the CBD medicinal products? That means with less than 1% of THC, for example. In that case, we have some decrees that regulate the condition of sale of those pharmaceutical products as a prescription drug. In this sense, the general rules for drugs applies. So these prescription drugs may be promoted, but only for the HCP, the healthcare professional. Okay. The problem is that after that also, a decree from the year 2000 establishes that any medical sample of drugs that contains any kind of narcotic or psychotropic substances and the promotion of the prescription of medicines containing such substances also, and professional advertising, it's restricted. So there are some inconsistencies between the cannabis laws and the general drugs laws. Let me see. Those inconsistencies really makes the difficult to conduct business in Uruguay. Furthermore, unlike what happens with other industries in Uruguay, the authorities actively control and severely sanction any activity that is not permitted. That is the case, for example, you are seeing in the slide that our authorities canceled an event that was promoting cannabis use. So, and then you can see also two examples that perfectly illustrate the cannabis advertising situation in Uruguay. In Uruguay, the state runs the cannabis business. The absence of publicity and the emphasis on prevention strangles any commercial strategy outside of the government ideas. This was an article published by the New York Times 1 year ago, and also one of our presidential candidates that was totally against the legalization of cannabis 2 years ago said that, by the way, banning marijuana advertising when the commerce of the substance is legalized is at this point a bad joke. That is the feeling right now related to advertising in Uruguay. So, in conclusion, recreational cannabis or medicinal psychoactive cannabis is clearly forbidden. So how can I make my product known? Well, for psychoactive cannabis, sadly for the moment, try a word-of-mouth strategy. That's the case in Uruguay. For CBD medicinal products, although the decree from the 2000 may apply and restrictions could apply, for example, for medical samples, for advertising, even for professionals, we believe that as it was categorized as a prescription drug, if you advertise only directed to healthcare professionals, and that will be allowed, and that will be the interpretation of the authorities. Also, this considering that last December the Congress approved a law whose purpose is the promotion and access to medical cannabis, including the aim to make healthcare professionals aware of their characteristics and effects. So, in that sense, we understand the Ministry of Health and the Institute of Control of Cannabis will not challenge events or advertising of CBD medicinal products. Regarding cosmetics and food with no more than 1% of THC, that means CBD, cosmetics, or food, except from some limitations, general limitations, advertising is in principle allowed. So, in conclusion, although we believe the cannabis advertising situation will change soon, or at least it will be relaxed so that any medicinal cannabis product can be advertised in line with the general rules, currently, cannabis advertising regulations pose severe restrictions, and the position of the authorities remains unclear. Thank you very much. Hello?
Oh, sorry, I was on mute. I just want to close the presentation and thank everyone for joining us. Special thank you to our gala speakers for their valuable insights on cannabis advertising in their parts of the world. And also thank you for Gala for sponsoring this webinar. I'd just like to invite everyone to visit the Gala website. It's on the slide, so galalaw.com, and also follow our blog for other valuable legal insights on advertising across the world. Thank you so much, everybody, and have a good day.